There's a lot of stuff that's been happening in the post-Bruin gun rights court case world, and today's guest is going to walk us through some of that stuff. Ladies and gentlemen, welcome to another T-Rex Talk. I want to introduce a guest of mine, Anthony, who you probably know as the Armed Scholar, a fantastic YouTube channel providing legal analysis specifically of Second Amendment stuff, because you're not just a YouTuber, you are actually a lawyer yourself.
Unfortunately, I'm one of those attorneys. Yeah.
Well, things have gotten complicated enough that I feel like attorneys are kind of a necessary evil to interpret the work of other attorneys. So, and before we go any further, I want to thank you publicly because you helped out quite a bit with the script of our Everything Wrong with Red Flag Laws Part 1, which we published last year. Mm-hmm. So thank you very much for all of your input on that and corrections.
You're too kind. They did a lot more than me. Yeah, they did a lot more than me. I did the scummy attorney red lines.
Well, there were mistakes in that script, and thanks to you, it's a solid video with a lot fewer mistakes in it. I still think I misspoke a couple of things there, but that's
nobody's perfect. But I'm definitely not perfect.
So we have collaborated a bit in the past, but I recommend your channel to people who are interested in stuff.
Thank you.
So first question that I have for you is how did you get involved in doing this? You've had your YouTube channel for a while, but were you always a gun person who became a lawyer, or were you a lawyer person who became a gun freedom advocate?
So I've done a comprehensive video on my channel way back in the day. So if anybody wants the long story, they can find that. It's, I think, titled How I Became the Armed Scholar. It's like 4 years old now. The long and short of it is when I was in undergrad, my senior year at UC Santa Barbara, there was a school shooting. And I lived in California, born and raised in California. Wasn't a big gun guy. My dad was a correctional officer, so we had firearms in the home, but we didn't go to the range every single day or anything like that. Wasn't really deep in the gun culture. But when that shooting happened, there was a lot of calls for red flag laws in California. Yeah. And a lot of my friend groups were calling for red flag laws. And eventually that was what led to California passing their comprehensive extreme risk protection orders. But during that period, instead of just following like everybody else, I said, you know what, let me get a little bit educated on what's really going on, what laws we already have. Let me learn a little bit about guns. And naturally, I actually went to YouTube. And early YouTubers like Eric from Iraq Veteran and John Lovell and all those guys, and consumed their content, learned more about firearms, did a lot of research on my own about laws in California and federal laws. And I think that's when the bug really hit. I think you're probably familiar, like a lot of guys, once you kind of get that gun bug, it just spirals.
Well, it is neat, though, that you kind of started off an unbiased observer, because there are a bunch of people who have this assumption that if you grew up with guns, you're going to be a gun guy. If you didn't grow up with guns, then you aren't tainted with the mind virus. But it's always fascinating to find guys who were kind of neutral, and as soon as they did unbiased third-party research, they picked...
Yeah, and I would say maybe I wasn't super unbiased. My family was leaning a little bit right. My dad is a correctional officer, law enforcement. I live in an area of California that, shockingly enough, is fairly red, ag and law enforcement. So I maybe had a right-leaning bias anyways, but I wasn't a gun nut or anything like that. Kind of naturally came about that, but never thought I would be doing what I'm doing now. That just, by the grace of God and his direction, led me down a path I would have never anticipated. And I'm very blessed to be where I'm at now, getting to do these things, because I just never would have thought.
Yeah, so you have done the YouTube channel, the commentary, quite a bit, but you also have worked for gun rights organizations, and you've also done stuff on your own. Like, what are you doing now? 2024, it's an election year. What are you doing this year?
Oh, that's a big, a lot. I feel like I'm busy a lot. Right now, I'm doing a lot more content creation than anything. It's a very unfortunate where we're at right now, where that is really how you move the needle and get everybody very informed. Would I love to just sit in an office all day and file lawsuits? Maybe. I don't know. It'd be a little bit harder now. But I'm leaning a lot into content creation. I started a podcast with my buddies who are also Second Amendment content creators. We had to come out here and talk to people like you. And working a lot with orgs behind the scenes, helping them, trying to get the word out about them so they get support. I do a lot on the local level also. I'm board of my local CRPA chapter, and we're trying to support them, trying to support the state org CRPA as well so they can continue to file lawsuits against the state of California and just all that goes along with that. It's, it's a lot. There's always something.
Yeah. Well, and everything has changed in this area of legal advocacy. I mean, content has changed too, but content's been changing for the last probably 10 years in YouTube. But legally, everything changed with the Bruin decision. And there still is fallout. There still is precedent being set. Everybody is scrambling on the left to figure out ways around Bruin. People are still scrambling on the right to make the most of Bruin. What's happening right now? Like, what's the general, like, how are the chips falling? Or is everything still in flight?
We have seen some chips fall, but there is still a lot that is trickling down. When you talk about a Supreme Court precedent like Bruin that hits, when you go back over Supreme Court precedent in this area of constitutional law, you have McDonald, Heller, Caetano, and that's really it that built that precedent. It's not an area of constitutional law that's been super flushed out like the First Amendment or anything like due process. And it just hasn't. I mean, I remember in law school when we did our first year con law, the Second Amendment section of the class was 2 cases and it took us 15 minutes to get through versus you spend days and days on the First Amendment. There are dedicated entire semesters they can spend on the First Amendment. So Bruin changed a lot. And when you ask what has happened and what each side is doing, it's a very loaded question. There's a lot going on.
A lot of stuff is in flight.
Yes.
But in flight feels like the wrong word for the legal process, which is usually very slow.
Very slow moving process. It's interesting. There are some cases that are moving very slow, and there are some cases that have been expedited and are moving very fast. A lot of that is based on where they're originating out of and what they're specifically challenging. So I guess to give the overarching breakdown of what Bruin was and what it did, New York State Rifle and Pistol Association versus Bruin is the case we're referring to. It was a 6-3 decision issued by the Supreme Court, written by Justice Thomas for the majority. You had some concurrences by Kavanaugh and some others that had some dicta in there I'm not a big fan of, that's caused some issues in some of the other lawsuits. But the first thing I usually point people to that Bruin did that often gets actually overlooked when people talk about Bruin is Bruin was really the first time you had the Supreme Court affirmatively say that your right to keep and bear arms, specifically bear arms outside the home, is in fact protected. Because what was happening after Heller is you had some courts in some states arguing that your right to self-defense, which they claim is the core of the Second Amendment, which we don't necessarily agree with. I mean, there are other purposes of the Second Amendment.
Many aspects to defense.
Yeah. They were saying that only existed within your home, and the second you walked outside the threshold of your home, magically your rights disappeared. And that was an argument New York was making for a very long time about why people did not have a fundamental right to concealed carry outside of their home for their own protection. So Bruin corrected that first, said this is a core aspect of the conduct that's clearly protected. And then they went in and did an analysis, which is on my shirt. This is why I have this shirt. It's text as informed by relevant history and tradition. And why that's important is because after Heller and some of these other decisions, you had a lot of states and lower courts that would interpret these cases using tiered-based scrutiny. Now, I'm not going to get into all the legal nuances because I don't want to bore everybody, but essentially it's this sliding scale. It's tiers. And you go from rational basis to intermediate scrutiny to strict scrutiny. Courts had kind of adopted that from the First Amendment realm of legal analysis, and they were trying to apply that to the Second Amendment. But what it ended up happening, because of tiered-based scrutiny, is when a state like California, for example, would pass a magazine ban, they would always say that there was a public interest in banning these items.
Of course, yeah.
And the government's interest would always outweigh
the
individuals.
Yeah.
And so they would always pass this tiered-based scrutiny. Now, there was a lot of courts that had different interpretations in how they would do this two-step approach, is what they would call it. And what Bruin did said, no, we don't do the two-step approach. We don't do tiered-based scrutiny. That is the incorrect type of analysis. You do text as informed by relevant history and tradition. which that is the precedent right now. And that is what is having a lot of trickle-down effect and is impacting cases from rifle bans, magazine bans, still concealed carry cases, because we're still fighting about concealed carry.
Oh, sure. Yeah.
And that's an interesting one that may be the first out of the gate. I know a lot of people maybe are surprised that after the Supreme Court strikes down a state like New York's concealed carry ban, they would have to reanalyze if their new concealed carry ban is proper or not.
Yeah.
And that's what's happening.
A fascinating thing. Yeah.
Yeah.
And that was one of my questions is, what happens when nobody listens to the Supreme Court? All these lower courts just keep overturning essentially what is the new Supreme Court precedent. At what point does the Supreme Court come back with a bigger hammer? Like, what does that look like?
It's hard because the Supreme Court has their own ways that they do things. They have their own procedures about how they want to address things. And you're also dealing with people with certain political belief systems that are at play here, obviously. Yeah. I get this question a lot about states or lower courts defying the Supreme Court. There are some procedural mechanisms that the judiciary and the Supreme Court has to their disposal, like expedited reviews, or where they can take a writ of cert before judgment and review a case before lower courts actually review things, and they can step in early and issue a merits decision. Some of these cases are asking for that. I don't believe it's the Antonyuk case. There is a case, I believe one of the ones filed by SAF, they've asked it's the Bianchi case. It deals with the rifle bans out of Maryland. They're asking for a writ of cert before judgment because they do not have faith that the Fourth Circuit is going to faithfully apply Bruin. So they're asking for the Supreme Court to step in early and correct things.
Do you think that is a good characterization of the Fourth Circuit?
That they are defying?
Well, that they won't apply things properly.
I would implore everybody, and you can find it, go on YouTube, listen to the Fourth Circuit Court of Appeals, their oral arguments in the Bianchi case. If you listen to a lot of those judges on the panel, they outright say either they think Bruin is circular, cannot be faithfully applied, or is just outright wrong. And we have seen plenty of lower courts outright defy not just the Supreme Court in Bruin, but they did it in Heller. You know, a lot of things should have been resolved after Heller, but we saw a 14-year span of courts acting like they didn't know how to actually do legal analysis.
Right. Yeah.
And they're trying to do the same thing now. They're just using different arguments because they can no longer lean on just two-step approach, tier-based scrutiny. So they're, in some ways, they've had to be a little bit more creative about the arguments that they're making. They just didn't have this rubber stamp of judicial approval that they could use as before. But yeah, I would say that at least my belief is that they will not faithfully apply Bruin. The Ninth Circuit has shown that they definitely will not faithfully apply Bruin. They have taken a case out of the hands of a lower court in the magazine ban case. They took it en banc. They broke a lot of their procedural rules of the Ninth Circuit to do that. So much so that you actually saw, for the first time I've ever seen, listening to these oral arguments, where you had the en banc panel, which is 11 random judges on the Ninth Circuit. You had some judges on the panel actively calling out the other judges in open court during oral arguments, saying that we broke our rules, this case is improper, you guys.
Interesting.
So it's when you that's things you would expect maybe to hear about happening behind closed doors, but to see that out in the open during oral arguments, it just shows that the divide. And even more so in that specific case, it wasn't just at oral arguments. When the Ninth Circuit was taking the case for review, you had dissenters, those same judges, calling out their colleagues, saying, what we're doing is wrong. This case should have been done in 2020. We're breaking our rules. We're not applying Bruin. What are we doing? We're signaling to all residents in California and others under the Ninth Circuit that we just do not believe in the Second Amendment. And we will do anything to not adhere to it, to not follow the Second Amendment. Yeah. So
it's a pretty fascinating situation that we find ourselves in. It's also an election year.
Oh, yeah.
I guess the question that I would ask is, there's a really obvious way that people, I think, understand these issues and think about what they can do. As they see different circuit courts behaving in certain ways, and they see different states behaving in different ways, there is an assumption that we will just leave jurisdictions that will not honor the Second Amendment, and we will just move to jurisdictions that do. So you're in California,
Yeah.
which is it's pretty much wears its agenda on its sleeve. We're in Tennessee. Now Tennessee's not quite as conservative as everyone assumes, and we've only had Republican rule. We've only had a Republican supermajority for a pretty short amount of time. It's not that long ago that we were all answering to Democratic majority legislature and Democratic governor. But we do have our permitless carry now. We've won some firearm freedoms over the last few years. Is that just the way things are going to break down? There's going to continue to be these wider divisions between judges, these wider divisions between jurisdictions. Like, what do you think is going to happen?
I think for the foreseeable future, yes. I think we're going to see a huge division between states that will actively try to protect Second Amendment rights versus states in courts that will not, that are going to try to find whatever loopholes. And this just happens in the legal system at large, and just in law, where that's what attorneys get paid for. That's when the state of California is paying their DOJ attorneys. They're paying them to find the holes to do what they want to do politically.
Find those Bowie knife laws.
Yep.
Drag them out.
Bowie knife laws. We were talking about recently, and I was mentioning with Lucas when we were doing the tour. At one point, California and some other states were even mentioning introducing a bill that would actually put regulations on holsters. Even these, and then for a while, California was shopping around an idea of precursor parts. They wanted to regulate every single little part of a firearm.
Every pin, every spring.
Yeah, background checks for triggers and all that. Now there was enough pushback where they walked that back. And the precursor part law that they actually passed only dealt with 80%ers and those things. And so we have a background check system for 80%ers and unfinished frames and receivers in California. And that was before the ATF stepped in. But to answer your question, the divide, I think it will get, you can see how already some states are continuing to engage in this conduct no matter what. No matter what the Supreme Court says, they're still going to try to do that. I think a lot of the correction is going to have to come at the ground level. That's why I'm a member of my local state orgs, and then my county orgs, 2A orgs. I helped open a couple in the Central Valley in California to get people more active, because a lot of this stuff is impacts people more at a local level. And then when it comes to people just saying, hey, maybe I'll leave this area, I just can't deal. I don't fault anybody. I'm one of my good friends and also a content creator. He left Massachusetts and came to Tennessee, and he's in the free state of Tennessee, and I don't blame him at all. Fortunate enough for me, I'm only 32. I'm still young. I guess I'm a glutton for punishment, so I'm still dealing with it.
Well, you have both the legal chops to understand what's going on, a voice to talk about it, and some experience and contact. So you are a little more valuable in the fight than somebody like me who's just like,
I don't know, you guys are pretty valuable.
Well, T-Rex has pulled together a bunch of people and I believe become greater than the sum of our parts. So if you can, viewers, if you can pull together with local organizations, you can do more than just on yourself. If you can combine legal knowledge and content creation knowledge and inform people, that just gets a whole lot more work done. So I'm really glad that you're still in California, even though I will point out there's room here.
My friends every day are trying to pull me. Unfortunately for me, I was asked to be a plaintiff in a lawsuit, and I actually joined as a plaintiff in the lawsuit. So I'm stuck in California, so I can continue to be the plaintiff in the...
There's a lot of folks in California that need better representation than they're getting from their governments. So I'm glad you're there.
Appreciate it.
Yeah. So what about the future? In the short term, you mentioned there will continue to be division getting wider. Then what? What do we see long term, next generation or so?
So the next generation is obviously very important, bringing up the younger guys and getting them interested in firearms and advocacy. In the immediate future, one of the biggest things we're going to see is before the end of this Supreme Court term, they are going to issue another Second Amendment decision. And that's going to be in the Rahimi case, which deals with the federal prohibitions under 922G8. Don't quote me on that. It's one of those. One of those.
We all know.
But that's the domestic violence restraining order prohibitions. And so that's a case that worked its way out of Texas federal courts into the Fifth Circuit, and it's now made its way to the Supreme Court. And they're going to issue their decision before the end of this term, late June, early July.
That's a perfect example of the divide as well, because conservatives are saying, hey, this is an important precedent as relates to weapons ownership, and the left is like, this is just about people who are domestic violence abusers. And
that's an interesting one. I would also recommend people go. I'm very on the fence about that one. The fact pattern of that one is not great for the 2A cause. If we win, it's going to be a very narrow vote margin, and probably going to be hopefully a very narrow opinion in how it's written. I always hope that either Alito or Thomas are writing those opinions, because I think they understand the issues enough to craft a decision that's not going to be super detrimental.
There are some. So going back to legal opinion versus the text, are you an originalist?
Yes.
I actually find as time goes on, it's harder and harder to really understand why you wouldn't be an originalist. If you're not an originalist, what are you even doing? Why are you not just a total postmodern, everything is subjective, make everything up on the fly, which actually some judges are pretty open about.
Oh yeah, some of the judges, I mean, there's and you deal with this in con law about theories about how certain judges in courts interpret the Constitution. Some are living Constitution, and it's malleable. Maybe it's principles that can be changed over time, and based on technology or society, we can kind of move the needle. And then you have textualists, originalists like Scalia and Thomas and some of those guys who are saying, no, the text means what it means. We look at it in context of what the founders meant in the time. And that was kind of the whole Bruin analysis, was really kind of taking it back to that.
Yes.
You look at the text, look at some of the historical documents, what was pretty much the main intent of that, or what did they really believe back then? And then you use that to look at what the government is now doing. And does the government's new regulation actually, mesh with that, or does it violate that? And if it violates that, then it does not, it's done for it. It should be struck down.
And I'm also an originalist. I don't believe that the Constitution is necessarily perfect, but it is the law that we have, and pretending like it doesn't apply leaves you with nothing. And it's interesting, we've seen kind of the same thing happen within the modern American church, where you do have an inspired piece of text, and you have a whole bunch of folks being like, well, let's just leave that behind. We can just figure out what's happening with the culture. We'll just follow the culture. It's irrelevant. And it's like, that doesn't go well.
Don't get me started on the TikTok pastors who interpret the Bible to get whatever worldview that they want out of it.
But the trend line is the same. When you get away from any type of objective standard, things just become a complete mess. And so I am really hoping that as the divide continues, one advantage to that division is that as the divide gets wider, it's easier to pick which side you want to be on. I think that is the only upside to this kind of fractured and pretty acrimonious divide that we have going on politically, is that people who were in the middle can just no longer be in the middle. You can't really pretend that there's a middle in the same way that you could 30 years ago.
I mean, we're seeing that in all realms. I mean, you just even talk about very popular media people like Joe Rogan. 10 years ago, if you were to say he was, or try to call him a right-wing conservative, people would laugh at that. He just wouldn't fit that mold. Nowadays, there is no firm middle. If you're either on this team or this team, which I have issues with that. I don't think that that's really how we should be, but that's where we're heading.
No, it's fascinating. If you let's say you're a football player, like if you're a Catholic football player and you say basic Catholic stuff in a Catholic school, the NFL will tell you that you do not line up with the NFL. Which technically you don't. So
the
NFL is correct in that statement. No, it's a fascinating time that we live in, and the cultural and political realms overlap so heavily now that, it's interesting that you, a legal scholar, are also a content.
I even hate that.
well, you have to wear both hats. To do the work that you want to do. The educational side is a larger cultural piece of the legal scholarship side and the legal application side.
Yeah, and I think going back to something you mentioned about like the individual, how do they help and move this forward? I never thought I would be in this position. I'm sure you guys never thought you'd be in this position that you guys are at now. Sometimes God works in very weird ways, and puts you down a path that no matter how much you try to resist, it's going to happen.
Yeah.
Again, I'm very blessed, but I think everybody can do something, and nobody thinks that they're going to be the ones to do X, Y, and Z. But I think we're all called to do certain things. So if you have that calling, especially when it comes to Second Amendment advocacy or any of this, jump in 2 feet.
Yeah. Oh, there's so much work to be done. The previous podcast interview, we talked about Alfred the Great, and Alfred the Great is obviously famous king of England, but no one expected him to be a king. No one expected him to be the guy to carry the load and do the work. And so, yeah, I think that we're at one of those interesting times of history where there are changes that are ongoing. There's division that is happening. Where things are right now is not sustainable. I don't mean that in necessarily a bad way or a good way. It's just like we are right in the middle of a change, cultural change, legal change, economic change, technological change. Lots of changes happening now. Things can't stay the way that they are. No one should be too surprised by me saying that.
Yeah, if you're not feeling that, then
nobody should be too disappointed by me saying that. Right now is not a great place to be. I don't want my kids to grow up in this moment. I would like us to pick one of the crossroads. I'd really like us to pick the right one.
Yeah.
And that be the world that our kids grow up in. So I appreciate you doing the work, even though it wasn't exactly what you thought you were going to be doing. And I'm confident that the people listening to this podcast will, if they're not already there, find themselves doing work that they didn't plan for.
Yeah.
Did you know that you would have a media audience when you were a kid and there were 3 channels on television and there was no internet, that would be a thing that you would do?
No.
We live in a crazy world.
Yeah.
All kinds of opportunities and pitfalls exist. The division that we see in the Second Amendment community in the political world today is in many ways heartbreaking, but in other ways it is just the outworking of stuff that we needed to deal with, decisions that we needed to make, moral positions that we needed to take. And so now we're at the point where that's pretty unavoidable. And I want to thank you for being bold and talking about that on the internet, because you do a kind of a thankless thing. Talking about legal code is not anybody's, it's not everybody's favorite thing.
Yeah, nothing I thought anybody would be interested when I first started doing it. Because even in the gun world, it was mainly just gun reviews. And then your brother and you guys early on YouTube were doing what you guys did. Nobody was really talking in depth about cases or anything like that.
I think it's huge. Going back to, we talked about them a little bit earlier before we started recording, the Second Amendment Foundation. My understanding is the Bruin decision, the lawyers that are arguing some of these cases, guys that you've worked with, a huge amount of that work got started because the Second Amendment Foundation started to do proper legal analysis of gun laws in a way that nobody else was doing. So that attention to detail, that focus on historical truth paid off.
That's also a very interesting and inside baseball thing about how even within the two-way community legal side, there are fractions about pre-Bruin about how to apply certain legal analysis. Some people still wanted to look at certain cases under the framework of tier-based scrutiny, and then you had another camp that said, no, we need to go to the originalist, text history and tradition analysis, and they advocated for that. So that's a great point. Again, inside baseball things. It worked out the way I think it should have worked out, and I think it's going to help us in the long run.
Yeah. And it does take all types. Like, I definitely know folks who were of the opinion back then that focusing on this boring academic level study was the wrong approach and it was not going to bear fruit. Instead, that we should do various other political tactics, which also were useful. Actually, all of the tactics at the same time was effective.
You need lobbyists, you need attorneys, you need people doing YouTube gun reviews to get people into the industry so that they can then move into politics or lawsuits and things like that. So it takes everybody.
Yeah. That's a fantastic way to end the podcast. I highly recommend that you guys go check out his YouTube channel and continue to do your analysis. And then I also want your opinions on the Everything Wrong with Red Flag Laws Part 2, because there's so much wrong with red flag laws that could potentially be an endless endless series if we wanted to take it that far. So keep an eye out for that. Keep an eye out for his videos, and thanks for watching T-Rex Talk, the official podcast of T-Rex Arms.